reserve any time for rebuttal?
I would, 5 minutes, please.
Okay, I will do my best to strategically time that interruption to let you know when you're about to invade the corpus of your reserved time. And with that, the panel is ready to proceed.
Thank you, Your Honor. May it please the court. My name is Donna Greenspan Solomon, and I represent the appellants, Veronica Ramos and Irvin Lopez. As I said, I'd like to reserve 5 minutes. Your Honors, the trial court abuses discretion in denying appellant's motion for new trial on 3 separate grounds. First,
about that motion for new trial, Ms. Solomon.
I'm sorry?
I'd like to ask you a question about the motion for new trial.
Sure.
It's fairly extensive and wordy, but it lacks something that I would have really enjoyed seeing, which is a case. Are there any case law that you can hang your hat on and direct me to that supports your right to a new trial?
I'm sorry, were you talking about in the motion for rehearing or in
The motion for new trial? The motion for new trial is several pages long and talks about what went on at trial, but it doesn't cite any legal authority or contain any legal analysis.
Yes, Your Honor. I would say, though, that it does contain all the elements that are required by the case law, for example, as far as being improper, harmful, incurable, unfairness, and due process. I can point those out in the motion for hearing if Your Honor would like.
Well, I was really interested to see if you had a case that you could direct me to that talked about those elements and whether or not there's a sufficient basis given for a new trial in this case. I understand that some broad general precepts are contained within the motion.
Well, Your Honor, it depends. And I guess I'm a little unclear. Are you talking specifically about the motion or in the?
Well, I was looking for something that had a fact pattern similar to what happened in this case, for example, with a case that says this is enough that the judge abused the discretion and it should be reversed because of Smith versus Jones or what have you.
Yes, Your Honor. And I'd like to, if I can, break up the 3 arguments because they are kind of all on different bases, if I might.
Sure.
And the first argument addresses our second point on appeal, which is that Dr. Perks violated both the trial court's order granting the appellant's motion in limine and then the court's orders during trial when Dr. Perks argued in closing that Ms. Ramos never made a complaint with the Board of Dentistry. Your Honor, referring to the closing argument, there's no objection made during the 9-page closing argument. And as initial matter, this issue is preserved for appeal, and that's Hudson versus States 278 Southern 3rd 257 in the initial brief, because what that court says is, as initial matter, the issue is preserved for appeal if the court has made a definitive ruling on the record admitting or excluding evidence either at or before trial. A party need not renew an objection or offer of proof to preserve a claim of error for appeal. Where the trial court's granting of a motion in limine constitutes a definite ruling on the record, a renewal of the motion is not required to preserve the issue for appeal. So I would argue
does that same rule apply when there's not an offer of evidence, but there's what appears to be characterized as improper closing argument?
I'm sorry, would you mind repeating that?
Does the same rule apply regarding the admission of evidence to an improper closing argument?
I believe it does. I would need to take a moment to find that, but with respect to closing.
The case you've cited in the brief deals with motions in limine regarding the admission of evidence. The problem that you're now arguing has to do with improper closing argument.
Right. Well, as far as closing argument, that has to do with the special standard that has to do with rehearing. And I'm sorry, Your Honor, I know I'm not answering your question directly, but
well, part of the problem that I'm having is to take off on what Judge Black was asking you about. Why is it reversible error for the trial court to deny the motion for new trial when your client did not cite a single case in the motion for new trial? Is
And
the court expected to do its own legal research to make the argument for your client?
no, Your Honor, but I would say that there is case law, and as it presented in the briefs having to do with closing argument. I understand that it was not
But that was not presented to the trial court, was it?
not specifically with names and cases, although the elements were, I would say that the elements were presented. And I can point that out with the elements.
Do you have any case that says that providing argument as far as the factual improprieties or the errors that your client contends happened at trial? Is there any case that says you can throw those out there without citing any legal authority to the trial court and that's reversible error?
I don't have that, Your Honor. If you would like, I could try to find that as supplemental authority.
Well, I'm sorry, but you had the chance to provide that in your brief. You provided in your brief as far as the bases for the claimed errors, but that was not presented to the trial court. In fact, one of the things that happened in this trial, to take off on another point made by Judge Black, a lot of the objections that were raised were not by counsel. They were interjected by the trial court, who was expressing concern as to some of the things that were going on. So I have some reservations about the lack of preservation and the lack of objections.
Yes, Your Honor. And what I would say to that is that a lot of times it wasn't necessary or possible for trial counsel to make those objections because the judge was affirmatively taking upon himself to sort of instruct the witness. But there were, I would say, enough where there were objections, like, for example, with respect to Mrs. Ramos talking about, going to the Board of Dentistry and that would be, more lucrative. And the fact that counsel.
There were a number of occasions where the court called the counsel called the defendant to the bench and had the defendant explain the basis for that. So it didn't look as though the court was abusing its discretion. It looked as though the court was trying its best to keep this within bounds and make it fair.
The court was in a very difficult position and did try repeatedly to admonish the defendant. But what the case law says is that when there is both objected to and objected to error, it would infuse the entire trial with the error. I mean, yes, the judge did make instructions, and therefore the attorney never really had the opportunity to raise those objections himself, but he did raise certain objections. And I think when you combine the raised objections and preserved objections with the objections that were not objected to specifically by the attorney, but they were by the judge, then that infused the entire trial with basically a lack of due process and for the trial as a whole. Did that answer your question?
Sure, close enough.
Thank you. Shall I continue?
It's fine.
Okay, so what I was saying specifically back just to the first point that has to do with the second point in appeal is that, the judge specifically said in a motion in limine, there can be no argument that she doesn't have to be the right to be here and that her only avenue is the Board of Dentistry. And that's the implication that you're giving. The implications, it's not the right place to resolve this dispute. It should be resolved by dentists, and that's not an argument that she could make. And nevertheless, despite both the motion in limine and the instructions specifically during trial, Ms. Ramos came out, Dr. Perks came out and said, so we have a situation in where we have other institutions that she could have gone to, but she decided to bring this to a courtroom. And that's why we are here today, because I think it's more lucrative. And the trial court then denied appellant's motion for new trial. That was an abuse of discretion. Trial court abuses its discretion in denying plaintiff's motion for new trial, where the violation of motion in limine is so prejudicial as to deny appellants a fair trial. And I think talking about the fact that she's bringing it to court instead of somewhere else because it's more lucrative, in fact, in violation of the judge's directions and motion for limine, was an abuse of discretion not to deny it on that basis. And counsel did have that, basis in the motion for hearing. Second, Your Honors, had to do with our first point on appeal. And after Dr. Perks insinuated during trial that appellants and their counsel had a duty to provide her with documents, appellant's counsel asked for a curative instruction, and the trial court did not directly rule on that request, but instead ruled that Dr. Perks could not argue in closing argument that appellants and their counsel had a duty to provide her with documents. Nevertheless, Dr. Perks ignored that ruling and argued in closing that appellants had such a duty, and further that they violated that duty. Appellant's counsel then asked to approach and objected that Dr. Perks had run the stop sign that was implemented by the court, and asked that he be allowed to even the scales by arguing to the jury that Dr. Perks' prior counsel hadn't even subpoenaed anyone, and Dr. Perks herself had, but the subpoenaed witness had not appeared, and the judge denied that request. And when a judge neither sustains an objection from the jury nor gives a curative instruction, the proper standard review should be that applied to improper comments is harmless error. And again, this was reversible error. The proper standard of review, the error was harmful on its face, impugning the integrity of the appellants and their counsel and resulting in a verdict that was inconsistent. Especially when she herself admitted when cross-examining Dr. Andrews that she, quote, didn't consider herself very experienced in the field, that leaving Dr. Andrews' testimony as an expert unchallenged. And then under the Special versus West Boca medical standard, even though the appellant did show here that that the error was not harmless, under Special versus Boca medical, where it's not shown that the improper it's actually the other party's burden to show that the improper closing argument did not contribute to the verdict, or there was no reasonable possibility that the error contributed to the verdict. Thus, the trial court abused its discretion in denying appellant's motion for new trial on this ground. And then this court has applied the special standard to alleged error in closing argument, finding that to the extent any error occurred in closing argument, there's no reasonable possibility, or that there's no reasonable possibility that an error contributed to the verdict. And then recently, the Florida Supreme Court again showed that the harmless error standard for civil cases that set forth in special applies in a civil context. And then finally, Your Honor, the court abused its discretion in denying appellant's motion for new trials. The trial was fundamentally unfair to appellants due to the egregious conduct of the pro se defendant. During the course of trial, and this that we talked about before, Dr. Perks repeatedly ignored the trial court's instructions and rulings. And then in addition to violating the court's instructions regarding her claims about withholding documents and going to the Board of Dentistry rather than to court, she repeatedly made unsworn self-serving statements before the jury in violation of the court's repeated admonishments to ask questions rather than make statements. And Dr. Perks made these improper statements both while she was examining witnesses, by interrupting appellant's counsel during his examination, and also by arguing with the witnesses. The judge's instructions and admonitions did nothing to curb Dr. Perks' conduct or her torrent of improper statements, which permeated the entire trial. And Your Honor, I think it's important to consider that it was unreasonable to expect the jury to parse through her stream of assertions to consider only those that she had actually stated under oath. I mean, she was testifying, but she was also acting as her own counsel. And I think a lot of the problem was she testified to her own, or made argument so much during her role as representing herself, that I think it would be really impossible for the judge to sort of parse that out from, well, what was said under oath and what was said as an argument to another witness. And then in some, Dr. Perks, and also in evaluating whether the errors were harmless, the court may consider the cumulative effect of the preserved and unpreserved error. In some, Dr. Perks' closing argument was improper, harmful, incurable, and so damaging to the fairness of the trial that the public's interest in our system of justice requires a new trial. The cumulative misconduct of Dr. Perks rendered the trial, taken as a whole, fundamentally flawed, and the court abuses discretion in denying the motion for a new trial. If your honors have no other questions, I'll like to reserve the rest of my time for rebuttal.
Thank you, counsel. You seem to hit your mark right on time. Thank
I'm
you.
sorry.
You
Okay.
hit your mark right on time.
Oh,
I
thank
didn't have to say anything. Bless you.
you. Thank you.
Pardon, Attorney Wheeler, you may respond.
Thank you, Your Honor. May it please the court, I'm Elizabeth Wheeler. I'm here today on behalf of the appellee, Dr. Elizabeth Perks. I'd like to focus my time this morning to show that appellant's challenge to Dr. Perks's closing argument is unpreserved for appellate review, as well as to point out several factual errors which appeared in the reply brief or were emphasized in the reply brief. Under our analysis of unpreserved error, this court is limited to examining for fundamental error pursuant to the Florida Supreme Court's analysis in Murphy. And they have not established fundamental error, which is very rare in civil cases, or even an abuse of the trial court's considerable discretion in ruling on a motion for new trial based upon improper closing argument. They've not established that the trial court's denial of the motion was arbitrary, fanciful, or unreasonable to the point that no reasonable jurist would have reached that same conclusion. Under the Supreme Court's discussion in Ailes versus Boemi, we know that proper preservation of error requires three components: a timely, contemporaneous objection at the time of the alleged error, a statement of the legal grounds for that objection, which is sufficiently specific to inform the trial court of the perceived error, and then the argument raised on appeal must be the specific contention asserted in the objection. Under the principle of preservation of error is designed not only for judicial economy, excuse me, but as well for fairness to the defending party, who has the right to be heard regarding the alleged objection and the right to revise the closing argument to respond to the ruling on the objection. Excuse me, I beg your pardon. As we examine this record, appellants rely upon a discussion that occurs at transcript page 903 to 904 to say that is a contemporaneous objection. However, that occurs at the conclusion of Dr. Perks' closing argument. She has no ability at that point to respond to the objection or to revise future comments to prevent compounding any potential error. Appellants also claim on page 11 of their reply brief that they filed a motion for mistrial. My review of the record does not disclose any motion for mistrial submitted by the appellants at any time. So the discussion at transcript page 903 to 904 is the blue through the stoplight argument. That argument doesn't ask the court to sustain an objection. It doesn't ask the court to correct an allegedly improper closing
Ms.
argument.
Wheeler, let me ask you a question. The record indicates that there were quite a number of occasions where your client was admonished to stay within the rules, to not testify and put evidence in the record on his own behalf, on her own behalf. It seemed like this judge was having a hard time controlling the flow. Why was that not enough to, why should we not say, you know what? That's enough. That's enough to grant a new trial here. This trial was not fair. This trial was not by the rules. We need to send this back.
Your Honor, my response would be that Judge Sniffen did do an excellent job managing this trial. He was very careful to preserve the fairness of the trial for both parties. And I believe that the points that are being brought out by appellant exaggerate the record. As you read the 939-page transcript, you're expecting just a circus based on the arguments made in the initial brief. But as you go back through that transcript, you find, well, except in a few occasions, this really was not that outrageous. It was not such that it vitiated the fairness of this trial. The judge
Excuse me, what does that outrageous mean?
I'm sorry,
Take
I
out the word that, you still have outrageous, right? So what degree of outrageousness are we looking at in terms of your argument when you say it's not that outrageous?
I misspoke. It's not outrageous at all, I believe. I mean, we're dealing with a pro se litigant.
Well,
We're
we were
dealing,
dealing with a pro se litigant who's an educated person, who's a professional. And what part of don't say that is not comprehensible to her?
our response is that she attempted to comply pursuant to the letter of the court's ruling.
The only thing that I saw from her behavior that might have constrained her is if the trial court would have threatened to fine her for every transgression or to strike her pleadings. And the trial court apparently didn't do that. And I will bow to the trial court's discretion because the trial court was there. But when you read some of this record, it's like, I don't have to listen to what you're saying. I can do what I want. There's nothing going to happen.
Your Honor, I don't believe that was her attitude toward the court because she, in other instances said.
It's hard when you're looking at black ink on white paper. I can see that with you. It's hard to tell what her attitude is because we don't have the benefit of a video being present. We're just looking at words that follow words. So you may be correct there, and I would concede that. I'm not trying to perhaps maybe embellish it, but it sounds like there was how about this? There's a failure to communicate here, or at least someone's not receiving the message being translated. Seems to be there on a fairly regular basis because if I understand correct, she didn't testify.
She
under
did
oath.
test, yet, Your Honor, she was
was called
examined
by
by
the
the plaintiff. Yes, Your Honor.
But in terms of her case, there was no testimony, but there was argument in closing that said about I'm this, I did that, and all these things. And
And the
sounds
objection,
like testimony.
the proper objection would be that that argument exceeds the testimony or outside the scope of the testimony or even perhaps misstates facts in the record. That's not the
So-
objections raised.
So I agree based on the record, on the one that you cited there, the counsel didn't ask for a curative instruction, about what she said, asked to make a rebuttal outside of the record. So the issue that was preserved, I understand quite well. And so apparently counsel didn't think it was outrageous. Would that be a fair inference for this court to draw since that was the nature of the objection made?
I believe it was, Your Honor. He did not object. He was going to just see what the jury did, I believe. It was a strategic call on his part to pocket this issue and use it if he had to, if he received an adverse jury verdict. I wanted to just, again, looking at page 904 of the transcript, to me, this was important, and I noticed this in preparing for the argument today. Judge Dr. Perks responds that she doesn't understand what Mr. Montgomery is arguing about blowing through stop signs. And she says, I believe if I had done something wrong, the court would have stopped her. And the judge
Is that where
responds,
where the trial judge says, I usually wait for someone basically to object before I interject?
exactly, Your Honor.
Okay,
And he
I'm on the
says,
same page you are. Thank you.
it's not a matter of fundamental error. I didn't hear an objection, and I'm not going to involve myself at this point in it. The other thing that I wanted to point out is that this discussion that Mr. Montgomery raises in transcript page 903 to 904 does not address at all the issue about this dispute should have been resolved by the Board of Dentistry. That's not an objection he raises. He doesn't raise any objection, but that's not part of his point that he makes to the court. So certainly under Ailes versus Moemi, that is not preserved for any type of appellate review beyond fundamental error. I wanted to also mention.
Counsel, can you comment on the motion for new trial?
Yes, Your Honor.
Why you feel it was adequate or not adequate?
Your Honor, we've argued that it is not adequate at all. It's cursory. It just outlines a catalog of events. It doesn't give the trial judge any benefit of legal argument or analysis under the Murphy standard. In my analysis, that motion for new trial needs to take the place of the objection that trial counsel failed to raise. And it should fully inform the court. It doesn't. In fact, it raises a bunch of points that I couldn't even trace to the transcript. It raises a bunch of stuff like she's going to take her money back to Mexico. He's going to take his money back to Mexico. I didn't see any of that. I don't know where that came from in the motion, but it's not legally sufficient. Cases discuss that motion for new trial under Murphy has to be, very informative to the court to preserve this issue now, or to take the place of the objection you failed to make. I wanted to also just point out that I do think that Dr. Perks's statement about omission of evidence starts out fairly at page 901 of the transcript. There was an omission of evidence that clarified that nothing was wrong with her. She makes that statement. And she picks up talking about the eForce records or the eForce website. That is a concept that she had developed with Dr. Andrews, the plaintiff's expert witness, on cross-examination without objection from trial counsel. And specifically, she's trying to find out, well, what medication was Ms. Ramos on to address this excruciating pain that she described, or the depression that she allegedly experienced, or even the insinuation that Dr. Perks prescribed antibiotics for too long. And Dr. Andrews himself seems to admit on cross-examination that that was a legitimate question, to see if he had reviewed Mrs. Ramos's records completely. And we see that discussion at transcript page 667. Appellants have framed their first issue stating that the court failed to give a curative instruction in response to appellant's objection. Appellees would respond, there was no objection and there was no request for a curative instruction. Similarly, there was no motion for mistrial, as erroneously stated in the reply brief at page 15. One more point I wanted to make. The appellants have edited their quote of Dr. Perks's closing argument to create an inappropriate suggestion concerning her statement that evil works in different ways. That discussion appears on transcript page 902. In fact, the appellants have deleted 25 lines of her closing argument there. And in fact, her reference to evil working in different ways appears to address her concern that someone is trying to eliminate her as a provider of dental services to an underserved community. The motion for new trial was superficial at best, presenting no legal argument, no analysis which would assist the trial court in ruling, as the appellant now asserts the trial court should have ruled. It's on unpreserved arguments. Under the Murphy standard, they bore the burden of establishing harmful error. This case differs substantially from Special versus West Boca Medical Center. West Boca Medical Center addressed preserved error. When you get into the Murphy standard, Murphy is clear that the complaining party has to show that the error was harmful, such that it reached down into the substance of the proceedings and vitiated their fairness. Turning to the argument that the whole proceedings were so flawed as to be a deprivation of due process based on cumulative misconduct. Again, we believe that that is exaggerated, and Judge Sniffen did an excellent job in managing the trial and protecting the parties, the rights of both parties to receive a fair trial. If there are no questions, I would conclude my argument by, again, adopting the arguments raised in our brief. It's clear that the court is very concerned about the preservation issue, rightfully so. And if this is unpreserved error, we are limited to Murphy. Murphy is excruciating, a very high standard for anyone to meet, and the appellants have not met it. Thank you.
Thank you.
Just confirm, counsel, there was no directed verdict motion and no motion for a judgment NOV, is that right?
That is correct, Your Honor.
That's all I have.
You're up. I'm sorry.
Go ahead. You got it.
Yeah.
Second.
You're
I
on.
got two. I have to get the time clock ready or you're gonna be out of time real fast.
Okay.
Okay, thank you. We will return to the appellant for rebuttal. Before you start, counsel, let me follow up with the discussion that I had with Attorney Wheeler with regard to that portion of the transcript around 903, 904, and the motion that was made. It brought to mind comments from during the time period when I sat as a trial judge. There was always that phrase amongst trial lawyers, including myself and others, about the trial judge, doing certain things from the bench. That is, if you're going to try my case, judge, make sure you win it for me. So the question about what Judge Sniffen did, saying I'm not going to act, seems to be indicative of his view and the fact that counsel didn't ask for certain things. I'm wondering now if we have a situation of, and I'm going to use terms so that you get the context, not that they are specific, a sense of buyer's remorse. I didn't do this. I was willing to let it go to the jury. And now, oops, I'd like the court to find a legal basis to alter my decision. Is that a fair or unfair characterization of the way counsel operated in this case in doing it? And I hope I've illustrated it, because I think it's an important, maybe not a tipping point, but a point. And I knew my question was going to be so long, I didn't start your time yet, so don't worry. Now I will let you answer and I will start your clock.
I appreciate the, Your Honor. Thank you. Your Honor, I would say that is not a fair characterization. I think here there really wasn't an opportunity for most of the time for the trial court, for the trial attorney to stop it, jump in, because the court was doing, admittedly, a lot of the heavy lifting in that regard, continuing to instruct the defendant, and she was pro se, and you don't want to kind of risk seeming to attack a pro se in front of a jury. I don't think it was a question of that. I think it was a question of the judge was doing all these things, but yet and making these rulings, but yet when trial counsel asked the judge to enforce its rulings, that's when things kind of came up empty. I disagree with counsel saying that these issues weren't preserved. I went through the issues specifically with respect to whether they had failed her in not providing documents, and also what I think is very egregious, saying, you're just in court here to have money, after the judge specifically said during the motion in limine and during trial, you can't say those specific things, which she specifically did. And I think she just really did thumb her nose at the judge. Also, counsel said the question was whether Dr. Perks had offered testimony on direct. Her testimony was by way of narrative in response to plaintiff's counsel. I don't believe that was where counsel said that she offered testimony in her direct case. I don't believe that is the case.
I believe counsel said it was on plaintiff.
I'm sorry?
Go ahead, Judge Black.
It was me, but that's okay.
Sorry.
At any point, after the judge raises his own concerns and your side did not raise any objection, and I understand that the judge has already told her what is okay, what's not. At any point, was there a motion for mistrial by your client?
No, Your Honor, and I did see that was an error I noticed in the brief myself last night. There was not a motion for mistrial.
And so it seems to me that if you're going to hang your hat on the argument, well, the judge took care of all the objections for us. Typically, if there's an objection and it's sustained, there could be a motion for mistrial. And so even though the judge might have made the objection for your side, I'm still concerned about the absence of any motion for mistrial during the trial, saying, Judge, this has gone so far beyond what you have instructed her. We now have to have a mistrial because this jury is been tainted.
And Your Honor, I understand what you're saying about, if it's sustained, you still do need the motion for mistrial. Here, though, I mean, I guess you could sort of.
So are you expecting that the trial judge is going to make his own motion for mistrial for your side? The answer is no, right?
No, but I don't think it was necessary here, because the proper what the court said in Salazar was the proper standard of review that should be applied to improper comments where the judge neither sustained the objection in front of the jury nor gave a curative instruction is that of harmless error, which it was not here. I would also say that the trial counsel did specifically raise, even in a motion in limine, the two really critical areas that she couldn't come in here and say that that we shouldn't be in court here because it's more lucrative, and that they
And that
somehow,
was done in closing argument, correct?
yeah.
Okay, and I agree, that's a pretty egregious statement to take place. At
Right.
the same time, there's no objection to that statement at the time it is made during closing argument. And we've
Well-
already covered background. And then in terms of the motion for a new trial, I tend to agree that it was legally insufficient. And so then the question becomes, do we defer to the trial court, who is in the best position to evaluate the impact of any impropriety on the jury and on the trial as a whole? And so I think you've got an uphill battle on that issue.
Well, Your Honor, with respect to the first issue about the contemporaneous objection, what trial counsel did was he didn't cut her off in front of the jury while she was speaking. But before he did his own closing argument, he asked for a sidebar, and he essentially raised an objection saying, hey, she just blew through the stop sign, and he wanted to know that he could then be free to tell the jury the truth, which was she wasn't just this pro se who had no help. She had attorneys all the way through. They could have helped her getting discovery. She tried to get discovery herself and didn't bring in the person she had subpoenaed. So I think that was really an abuse of discretion by the court after the court had already said, no, she can't do this. She can't do these things. And he really tied the trial court's hands, the trial attorney's hands. At that point, the trial attorney was just going into closing argument, just about to go back into closing argument, could have made those corrections right then and there. So I would not agree that there was no contemporaneous objection at that point, because he wanted to be able to sort of even out the playing field. And the way he thought best to do that was to go in a sidebar rather than continue to look like a bully.
I have to say that I read that, and what he was asking the court to do seemed to me to go well beyond what was an appropriate curative instruction.
I understand, Your Honor, but my point really kind of was that there was no contemporaneous objection, and I think that he, just by going into a sidebar while he was in the midst of closing argument, I would not agree that there was no contemporaneous objection at that point. And like I said, he had gotten the order granting the motion in limine. He knew this was going to, these were going to be major issues, and he, trial counsel, I think the court was in a difficult position. I think trial counsel was in a difficult position because there was just no restraining this particular defendant. And I do believe it permeated the entire trial. I understand what the court is saying about the motion for rehearing, but I think there was enough in there that the elements were argued, and I could, if Your Honor wanted, go through exactly where those elements were argued within the motion for rehearing, if Your Honor would like me to do that at this point. And
I think you probably need to sum up it, well past 5 minutes.
Okay,
so
thank you.
You could bring this up to us in 15 seconds or so, but I wanted to cut you off.
Thank you, Your Honor. I would just say then in closing that if you read this transcript as a whole, which I know Your Honors have done, I think it really just kind of jumps out on the page to you what an abuse of process this was, and really what an abuse, by, as you say, a well-educated, intelligent pro se who just got away with thumbing her nose at the judge. And the jury was really left in an unfortunate position where they couldn't segregate out what she was testifying, what was actual fact, and what she presented on her side of the case was really nothing. She did this all by narrative in response to a cross-examination. And I would ask Your Honors respectfully to vacate the order denying the motion for new trial and to vacate the jury verdict and the final judgment. Thank you.
Thank you. Thank you both, and appreciate your working with the court, dealing with all the questions that we asked both of you. Very much appreciate your efforts in that regard. And I'm sure the panel does it well, as well, pardon me. With that, I'll allow you all to, I guess, electronically segue back to wherever it is that they have created this technological